School, and we together with FTI Consulting are hosting this event entitled "Has the Constitutional Court Killed the Gas Industry?" And the reason that we are discussing this is that some years ago, NERSA made a decision on gas pricing based on a certain methodology, and certain of the large gas customers took the matter to court, and it wended its way through several courts until it ultimately reached the Constitutional Court last year, which has now handed down a judgment. And that judgment is of great concern to us in the energy sector, and we want to understand it fully. And that's why we've got three experts with us this evening who are going to take us through it and see what the implications are. The big concern is that the prescripts the judgment has set for NERSA regarding the way tariffs should be determined might not be enabling of investment. And we know that we need increased investment in the gas sector because our power sector is increasingly moving to renewables, and that means solar, which means there's no sunlight at night, at which time you need things like gas, which can start up and shut down quickly, and the same with wind, which doesn't blow constantly all the time. So gas is a very important adjunct to a transition towards renewable power generation. So it's, in addition to power generation, of course, the industrial customers who are very concerned about gas and gas pricing. So that's why this is such a topical issue. The order of proceedings is I'm going to introduce all three of the speakers up front, and then we are going to hear from Nomfundo Maseti, who's the full-time regulator at NERSA responsible for the gas industry, and then from Steve Labson, and then from Professor Firoz Cachalia. Then there may be one or two questions and answers between myself and the panel, or between the panel themselves, and then we'll open it to questions from the floor. So the way to pose your question from the floor is to make use of the chat facility. If you move your mouse, you should see a band along the bottom of your screen, and there's a little sort of square box which says chat, and that's the one to be clicking on, and then you can write your question in there. When we get to the question and answer, Professor Lwazi Ngubevana will take over as the facilitator. He'll be reading out the questions and selecting the most interesting questions and getting our panelists to answer. So let me just briefly introduce our panelists, starting with Nomfundo, who has been a full-time regulator at NERSA for some years now. And before that worked at the Department of Trade and Industry, and before that at the Competition Commission. So she has a lot of experience in regulatory and policy issues, and no doubt has been applying her mind to the gas industry and this judgment ever since it came out last year. She has a BA Honours in Economics and a postgraduate diploma in Economics for Competition Law. Steve Labson, Dr. Steve Labson, is a consulting economist with over 25 years international experience, advising governments and major power sectors on reform initiatives and regulation and pricing frameworks and things like that. He's acted as a senior external advisor to the state-owned enterprises since 2002 and has provided expert testimony to the High Court on regulatory issues. So he's eminently well qualified to comment on this. He has a PhD in economics from the University of California at Berkeley. And then we also have Professor Firoz Cachalia, who's a professor of law at Wits Business School. He dates back some time because he has a history in struggle years, and he's also been involved in politics. He's been on the Gauteng provincial legislature. He's been the MEC for community safety and the MEC for economic development in Gauteng, and active in various roles as speaker in Gauteng provincial government. He's worked for legal firms, is widely published in legal matters and has a particular interest in administrative law. So I think you'll agree with me, we have eminently qualified people to talk about this judgment. So I'm going to hand over now to Nomfundo, and I'm going to turn off my camera. Over to you, Nomfundo.
All right, thank you very much, Dr. Crompton, for inviting me to share my views regarding the implications of the Constitutional Court judgment on the in turning the decision or overturning the decision of the energy regulator on the maximum price that we have approved for Sasol gas. And as you correctly pointed out, that maximum price was approved based on the methodology, and of which methodology the approach that was taken is that we looked at the benchmark to try and arrive at the price of, at the maximum gas price. And that benchmark looked at the various fuels competing with gas. For instance, we looked at the price of electricity. Obviously, we know the challenges around the price of electricity, but we had to look at what were the possible substitutes in order for us to then migrate from the pricing regime at the time. And also the price of coal, and we did a weighted average with the price of heavy fuel oil, that is HFO, LPG as well. So we did a weighted average, and then we arrive at the maximum price of gas. So one will then submit information and then calculate that price based on that methodology. Now, I think it's important for me to set out upfront as to what was the methodology. So that is the first method that gas traders could use to arrive at the maximum, not the actual price of gas. It's just the maximum, the limit. So the second approach that we allowed was to use the cost pass-through. So where then it will be the onus of the gas trader to set out all the costs that they've incurred, and then we'll do a verification. So in addition to this, we'll also put a trading margin, since some of the independent traders did not own the network, such as the distribution pipeline or transmission pipeline. So you also want to then recognize the fact that there will be certain assets that are typically trading assets that they need to recover the cost of using those assets. Now we then approve the price of gas for Sasol based on that methodology, and Sasol used the benchmark, meaning that it has arrived at, it has used the price of other fuels, coal, HFO, LPG, diesel, as well as electricity. And this is not unusual. You do find it in other parts of the world as well, that kind of methodology when you price gas. So now coming back to the challenge that was first taken to the High Court, and at that stage, obviously NERSA won the first challenge at the High Court. The matter went to the SCA. Obviously, the Supreme Court of Appeal did not agree with NERSA in the sense that it criticized the methodology, although the parties were out of time in terms of challenging the decision of NERSA with respect to the methodology. And that's what the High Court also stated, that they did not even give reasons, so they were completely out of time, and they understood that they were out of time, so they challenged only the decision of the maximum price, of which decision was made in terms of that methodology. So somehow the arguments then overspilled to the methodology itself. Now at the Constitutional Court, I think there are good things that came out of the judgment. One of the good things that came out of the judgment, the Constitutional Court did not criticize the approach of the National Energy Regulator insofar as to try and come up with benchmarking approach in order to arrive at the price of gas. So the benchmarking approach is an acceptable principle. So that is the first good thing that came out of it. So what we were also looking at from our side was to try and find a competitive price using a benchmark. So whether that benchmark that we used was a competitive benchmark is what then the Constitutional Court had criticized, to say that the benchmarking itself, yes, it's an acceptable principle, but let's look at what else did you do? Did you, for instance, look at the cost of the monopolist? In this case, it was Sasol. Did we look at the cost so that we can be able to see whether, when we try to set a maximum price, whether that maximum price will be at a competitive level, so that we can be able to say that we have achieved what we set out to achieve, what the law requires of us as the regulator, as we are required to make sure that when we regulate prices, we mimic competitive outcomes. What could be the outcome in a competitive market situation? Have we arrived at that? Have we achieved that? And that is in terms of our own Gas Act. So that is the part that the applicants challenged, to say that NERSA did not do that because the methodology that they've used, it arrives at prices that are quite excessive. And it therefore does not even achieve the objectives of the Act. One of the objectives of the Act is to make sure that we promote a competitive gas market. Number two is also to promote access to gas in an affordable and safe manner. That's the second one. And then also to make sure that, yes, we facilitate investment. So you can tell from these that our role is very difficult, because we have to balance the interest of different stakeholders who obviously have different economic interest, depending on which side you are at. So if you are on the supply side, such as the gas traders, obviously you are looking at the price that is going to be higher. Now, if you are a customer from the demand side, obviously you want a price that will be much less. And as you know, that there are industries that utilize energy quite intensively. So the cost of energy, whether it's gas or electricity or any other source of energy, is going to have very significant impact on their production processes, so as an input cost. So that is quite critical, especially also for the manufacturing sector. So these are some of the things that we are confronted with. But at the same time, we wanted to make sure that the price is not too low, such that you discourage investment, and that the price also is not too high, such that there is no market for gas, there is no demand for gas. So those things are quite important for us. And really we have to come in the middle. And at that stage, given the methodology that was already approved and it was not challenged at the time, then we had to determine a price based on that methodology. So we felt at that stage that we managed to then come in the middle and come up with a price that we believe was a reasonable price for the market. So in terms of the judgment, as I indicated, some of the things that the judgment pointed out is the issue of equitable treatment. And by equitable treatment, the judges quoted our own, one of the objectives of the Act, which is section 2E of the Act, which calls for fairness as well as equitable treatment. So if one goes then to the objectives of the Act, you will see there that it talks about equity. So it introduced that issue very sharply, that when you then have NERSA, you have to determine the limit, the upper bound, which is the limit in the price of gas. You need to do a cost price comparison. That is the simplification that I'm coming up with, because there's nothing in economics that states that one has to determine a price of gas based on cost. There is nothing like that that says so. So the price is determined by the forces of demand and supply. And unfortunately in South Africa, because the market for gas is still very much in an infant stage, we are in an immature market. So it's unlike in other markets, such as in the UK and parts of the EU, as well as in the US, where the price of gas is determined by the forces of demand and supply. So unfortunately, we're not in that space where the price is determined through the hubs, unfortunately. And then in other markets, the price is obviously referenced to oil products and sometimes to heavy fuel oil, and then also and also crude oil, especially the LNG, which is the liquefied natural gas. So that's how then it is priced. So from our side, we had that challenge. So we were trying to find the competitive price. So the judges then did not say that the price of gas must be based on the marginal cost. They've only stated that we need to know the marginal cost of a dominant supplier or a monopolist. And that is for us is not unusual, because even in economics, you need to, in economics, you need to understand what is the cost of this supplier so that you are able then to see the gap between the cost as well as the price that is ultimately charged. So we felt that perhaps it's just the sanity test that we need to conduct from our side, so that we know exactly where the actual cost or this, because the judgment talks about actual cost and also refers to the marginal cost. So once you know that, you are also able then to see the difference between what is the cost incurred as well as the final price that has been charged. But in our case, it will not be the final actual price that is charged, but it will be the limit or the maximum that the supplier or the gas trader is required or is allowed to charge. So that's, at least from our side, the important consideration, economic consideration, as opposed to taking it as a limit, as a maximum price itself that needs to be set at a marginal cost. That is not how we understood it. And therefore, even the methodology that we had to come up with, it did not set the maximum price at a marginal cost. But what we have done in the methodology this time was to incorporate an element that will require us, once we receive applications from any trader, to at least consider what the marginal cost is of that trader. So the trader has the cost information. It will then provide us as a regulator with that cost information. Based on that cost information, we will then be able to tell what is the marginal cost and verify that. But it does not mean that the marginal cost is the one that will tell us where the price is supposed to be. No, what we did, we have come up with an index. That index that we have come up with, because now we are still sticking to a competitive benchmark, as we know that even the courts have agreed that a benchmark is an acceptable principle. So in this case, we have used the benchmark of the different hubs. Henry Hub is one of them. TTF is also one of them. And we did the weighting of each of those hubs. And then we've come with the maximum price, and we did consultations. It was acceptable. Also, the incumbent, which is the supplier of gas or the owner of gas in South Africa, Sasol, had also agreed with the approach of looking at the hubs for NERSA to look into a competitive benchmark. Perhaps the differences will only be in terms of which hubs are you going to consider and which hubs are you going to assign a higher weight. That is just those differences. Otherwise, it was acceptable. And that's how we're now coming up with the price of gas. And the outcomes of that is that it obviously, yes, the slide is quite important, because then it shows here we were trying to determine the maximum price is showing the previous gas prices. So if you look at the graph that is now shown on the screen, you will see that the proposed price is now in the middle. I'm not able to see properly here so that I can be able to explain the graph. Yeah, so you see the solid line. The solid line, it will be the LNG ceiling prices. And then the total cost of gas, you see, is the one that is at the bottom, the solid black line at the bottom. So that will be the cost, and then that will be what you may consider to be what the actual cost, or maybe the marginal cost, depending on what we have considered. And from our side, we consider the acquisition cost. So it will lie there, and then the proposed price, maximum price that we will need to look at is the one that is the dotted line. So you will see the current LNG prices that we have looked at. And remember, the LNG prices that we looked at so far are those that are referenced to oil prices. And you know that the price of gas determined in terms of crude oil, in terms of those contracts, is going to be higher in most cases compared to a price of gas determined in the hubs. So the hub pricing is the one that is much more competitive, because it is the price determined in terms of the demand and supply forces. So that is the way that gas prices around the world will be determined in any event. It is the mixture of that, and also it will also be the spot price now that we have begun to see globally, due to the fact that some of these long-term contracts, LNG contracts, have expired, and now you see a lot of people now buying from the hubs and on spot in terms of the purchases for LNG. So yes, and here we just sharing the slide here to show what does the GE really is just the gas energy, because it's the molecule that we're talking about here. We are not including the cost of the infrastructure, the transmission, storage, regasification, and all of those, they're outside of this price. So the maximum is just the fuel cost. And even if we're talking about electricity now, as the country has included gas now for generation of electricity, the one key thing, especially now that the cost of renewables is coming down, what is key for gas as well, if it has to come, whether it comes at mid-merit or it comes at base load, and it will be very difficult to come at base load if the price, the fuel cost is too high. So it is important that then we look carefully at the price of gas. And we believe that with the current price levels, I think gas will compete quite favorably also alongside renewables. And it can play a crucial role in terms of being utilized at mid-merit. So this slide I've already dealt with regards to not making the price of gas too low or making it too high. Can
we round up, please, Nomfundo?
Yes, I'm rounding up now. Thank you so much. So, so in terms of what we have achieved, we think that the price is quite, it's at right levels. At least we didn't get unfair criticism. We actually got very good input from the suppliers. The only thing that will happen with the incumbent is that obviously the previous price was too high, and also with the previous regime, Dr. Crompton, of the MVP market value pricing before NERSA regulated, you will recall that it was also very high. So we don't think that the Constitutional Court will kill gas projects in South Africa in terms of the methodology that NERSA has come up with and incorporated the principles articulated in the Constitutional Court judgment. We think that it will still make gas quite attractive and to compete quite favorably alongside the renewables. Thank you so much.
Thank you very much, Nomfundo, for those insightful remarks. The question that I'm sure is going for you, so you can start thinking about the answer, is with this new methodology, at half the price it used to be, the gas, is anybody going to invest in the gas industry? But we'll keep that on hold for the moment. Let's move on then to Dr. Steve Labson. Over to you, Steve. What are your thoughts on this judgment? Has it killed the gas industry?
Thank you, Dr. Crompton. Yes, first I'd like to just affirm that the regulatory methodology used in pricing natural gas has been shown internationally to have the potential to hugely impact the development of the sector. We saw this in North America during the 1980s, where many people felt that it motivated the energy and gas reform initiatives there, and across Europe in the 1990s. But in coming to the Constitutional Court's judgment, I'd like to offer three brief elements of that decision that I think will help motivate our discussion today. Firstly, methodology matters. My understanding of the case is that the court, citing relevant jurisprudence, found that the process or methodology by which NERSA made its price determination must rationally be linked to the purpose of that determination. Then secondly, the court accepted NERSA's position that the purpose of the price determination was to replicate or mimic a competitive market outcome. With these two elements of the decision, my understanding is the court referred to the familiar and often misunderstood premise that competitive market conditions lead to firm pricing their products at a level where price equals marginal cost. This is where we're really moving into the areas as an economist I find very important and interesting. Having found no meaningful reference to the marginal costs in NERSA's determination of maximum allowed prices, the link between the means and the end of the administrative action, the price determination, was found to have been broken, and that NERSA's maximum price decision was irrational. I'm not a lawyer, so I won't comment further on those issues, but it does motivate quite a few issues that come to mind as an economist. First, it seems fair to assume that the court was referring to conditions of the competitive markets, that they were really thinking of long-run marginal costs. I would have thought the court would certainly be aware that short-run marginal costs would not recover basic fixed costs of production, which obviously are very significant in this industry. Indeed, this is why NERSA and other regulators often assess long-run costs in providing regulated services, cost of service type methodologies, which is done in gas pipelines, transport tariffs, for example. But the issue here is a cost-based approach will meet other criteria, such as allowing for the recovery of efficiently and prudently incurred costs. It arguably does not reflect the outcome of a competitive upstream gas market. And if we think about the basic premise that I understand the judgment to provide, I think of it in terms of a competitive market standard. That is, that pricing should mimic the outcome of a competitive market. Can the methodology do that? That would be the test. The textbook definition of a long-run competitive outcome is based on an assumption that all firms eventually take up the same low-cost production processes, such that the price equals long-run marginal cost across the industry. But you can't just manufacture a low-cost gas field. Royalties on production might serve to level out the financial advantages enjoyed by low-cost fields, but it's generally accepted that in competitive gas markets, low-cost producers will price up to the market price. The basic takeaway here is that for national gas markets, and natural resources more generally, the competitive market price is not generally determined by individual producers' long-run marginal cost, and that even in the long run, low-cost producers will enjoy higher levels of profits than high-cost producers. Again, this is subject to caveats of royalties, resource taxes, and other policies such as those. But for the time being, those issues are admittedly a bit academic. As you've just been briefed, NERSA has chosen a very different approach to pricing upstream supply of pipe gas, employing the benchmark approach, which Ms. Maseti fully briefed you on just now. While NERSA has certainly subjected this approach to a rigorous stakeholder consultation, it seems to me that the revised approach to pricing might also be found to be disconnected from its intended purpose, that being to replicate the outcome of a competitive market. So to me, this is really the beginning, not the end. And this would be based on the assumption that the court has meant to establish what I'm referring to rather loosely, I suppose, as a competitive market standard. If that is to set the bar to which the methodology is to be assessed, I can see quite a few areas in which it might potentially fail. I know I'm doing some independent research myself right now, and the initial results don't look promising. But of course, that's just one researcher's opinion, and this will take quite a bit of peer review and further discussion. But I do suspect that these types of issues will be brought in front of the courts. And the first one being whether the revised benchmark approach does indeed adequately reflect the outcome of a competitive market. Certainly, it reflects the outcome of competitive North American, UK, and Netherlands markets, but whether there's an integrated global market that includes South Africa is an empirical question that I think will need to be answered. Thanks.
Thanks very much, Steve. Much appreciated. We got some interesting points of view there. And one of the questions which I'm sure is going to be coming to you, since you've said that there are likely to be further court developments or legal developments along this train, is are investors going to feel confident enough of the regulatory dispensation to invest in gas and other energy infrastructure before these further legal processes happen? So if you could start thinking about that question when we come around after Firoz, we'll get your answer to that. So let's move right along then to Professor Firoz Cachalia, who's Professor of Law at Wits University. Firoz, how does it look from a lawyer's point of view? Over to you.
Thanks, Rod. So thank you for inviting me. And thanks to Nomfundo and Steve for their presentations, which were very illuminating for me. I'm not an economist, and I know very little about the gas market, except that my friends sometimes complain that I contain too much gas sometimes and disgorge too much. But otherwise, I'm certainly I don't have any expertise in this area, but I can speak to the legal aspects of this very important judgment. It's important because it is, as far as I'm aware, the first time that the Constitutional Court has reviewed a pricing decision of a utility regulator in South Africa. And so its reasoning is of great interest. And of course, since we have a jurisdiction in which the Constitutional Court is the apex court, and in which the Constitution is supreme, on all legal questions, the Constitutional Court's decision, it has the final word. So what Justice Kampepe said for the majority in this judgment is now the law in South Africa. Of course, it does not mean that when future pricing decisions, if and when future pricing decisions are challenged, that there will not be any wiggle room for challenging for trying to obtain a different result. But I don't want to go into what that wiggle room might be at this point. So this is how I understand the decision. First of all, that pricing decisions, which are a very distinctive class of administrative decisions, pricing decisions of utilities, constitute administrative action and are therefore subject to judicial review under the Promotion of Justice, Administrative Justice Act, as well as Section 33 of the Constitution. Now, that has implications not only for NERSA, but for other price regulators and perhaps for other regulatory agencies, because it means that pricing decisions, which now clearly constitute administrative action, are subject to the test of lawfulness, reasonableness, and procedural fairness under Section 33 of the Constitution, and as those grounds of review are specifically delineated under Section 6 of PAJA. Now, let's be clear that Justice Kambebe did not say that the pricing methodology itself constitutes administrative action. That is what was said in the High Court. That view was overturned, if you like, in the Constitutional Court. So Justice Kambebe said that's not, the pricing methodology itself is not administrative action. What is administrative action is the pricing decision. Now, in that regard, the Constitutional Court, specifically the Constitutional Court, what did it say about NERSA's pricing decision? Because there appears to be some question about what it said. It said that NERSA's failure to take account of Sasol's marginal costs was both procedurally and substantively unfair. Now, that means that Sasol's costs are a mandatory input. So in that respect, I might want to take some issue with Nomfundo, are a mandatory input in deciding Sasol's maximum gas price. But I think where Nomfundo is absolutely correct is that these marginal costs at the very most constitute the floor, not the ceiling. The CC's decision does not eliminate, therefore, NERSA's discretion to determine the maximum price by taking a number of considerations into account, including the profitability of the industry, the need to secure further investment, and so forth, which are also objectives which are set out in the governing legislation, the Gas Act. Now, what this means is that, and I want to stress this, if the Constitutional Court says your pricing decisions, NERSA, are administrative action, and you have to comply with all three requirements of Section 33 of the Constitution, lawfulness, reasonableness, and procedural fairness, although this specific decision turned on a finding of irrationality, that has implications for the way NERSA in the future conducts itself, both with respect to the process of coming to a decision and the decision itself, which now have to satisfy both statutory and constitutional standards. It is not only the grounds of review from a legal point of view that are important. It is also the standard of review that the court adopted in coming to its decision, because it's really the standard of review that determines whether a party challenging a pricing decision succeeds or not. And in this regard, I would say that it's important for NERSA to recognize that the court adopted a rather strict standard under which it is signaling that it will take a very in-depth look at any pricing decision that is arrived at in the future. What I would call a species of hard look review. which is a standard that, for instance, in the United States, courts adopted. It's a very different legal system, but it's a standard that they adopted when they didn't trust the regulators, when they thought that the regulators might be captured by the industry they were required to regulate. So I make that point only to underscore the fact that it's not only the substance of the decision that the Constitutional Court arrived at, but the standard of review, which is something we can come back to in discussion. Now, as regards the finding that the pricing decision, not the pricing methodology, although Steve is quite right that the way the Constitutional Court came back, the court didn't say that the methodology was reviewable because it constituted administrative action, but it did say that the pricing decision had to be both procedurally and substantively rational. And that's the way, that's what created the feedback loop. That is what gave the court the opportunity to look back at the way NERSA arrived at its decision. What decision? That the pricing decision was irrational because it did not take account of. That's not a requirement that marginal costs are the only consideration. It's one consideration. It does not, I want to emphasize, preclude consideration of profitability, for instance, investment considerations and so forth. And I think, as far as I'm aware, it's also justified by orthodox economic theory, as well as the way the governing statute is framed. So I think that one has to be careful about criticizing the Constitutional Court. If the concern is about future investment in the gas industry, having regard to the energy transition, it might, and this decision will have this effect, and perhaps there's a case for legislative reform. But you know, I don't think the court itself can be criticized. From the point of view of orthodox economic theory, this is a criterion the court said has to be taken into account because it encourages efficiency. That is, it encourages the firm with market power to address cost issues efficiently. That is, not to engage in transfer pricing and so forth, padding its costs, as well as considered from a distributive justice point of view, a distributive fairness point of view. So taking the interests of consumers into account, which of course also has an impact on the economy if this constitutes an input costs for purchases of gas manufacturers, for example, and so forth. So we can come back to this discussion about whether the court's decision constrains future investment. But my interpretation of the judgment is that there's considerable room for that NERSA still has considerable room flexibility in arriving at a maximum price, which would include a benchmarking exercise. Let me conclude with one observation, which has a bearing on this discussion. There are other issues that I will not go into, which concern the questions about the proper relationship between courts and regulators, And there are issues, for instance, of judicial deference and so forth, but unless there's an interest in that and under questions, I won't deal with them in my presentation. I will conclude with this question. I have the impression that part of the problem giving rise to this discussion, as well as the fact that we've had, we've had a High Court decision, we've had a Supreme Court of Appeal decision, and now a Constitutional Court decision with a dissent, is that the legislation is framed in a way which sets out conflicting regulatory objectives. One other way, perhaps, to put the point is that it might be that there's a degree of ambiguity relating to the objectives of regulation. So there are one of two ways to interpret the purposes set out in the legislation. One is to say that it is NERSA's mandate in setting prices to mimic a competitive market price, as Stephen was suggesting, for instance. A second way to think about the governing legislation is to say that NERSA, in setting prices, that the purpose, its purpose or the regulatory purpose in setting prices is to control market power by setting a price which achieves a fair balance between producers and consumers. Now, it does make a difference, I think, in the conversation we are having. It seems to me that the first interpretation is the position that the Supreme Court of Appeal took. They said that it was irrational for NERSA to set the price that it did and to adopt the methodology that it did, which had the effect of raising rather than reducing prices, aimed at mimicking the outcome that would be achieved in a competitive market. That's not the way I understand Justice Kampepe's reasoning. She appeared to be saying that it should be recognized in the gas industry that NERSA is dealing with a firm that has market power. In other words, that it has to regulate market prices in the absence of competition. And I think that interpretation led her to the view, one, that the benchmarking exercise is in itself not irrational. It could be part of a pricing methodology. But two, that marginal costs had to be taken into account in setting a maximum price, not in determining a maximum price. I'll end there.
Thank you very much, Firoz, for those insightful remarks and that very clear explanation. I guess the question that is going to come around to you is that if the Constitutional Court adopts this, what you call hard look approach, is that something that might scare off investors? So think that question over while we see if we've got time. I think what we're going to do is ask each of you to just give a very short response to the questions I posed. So beginning with you, Nomfundo, and let me say to those of you who are participating in this discussion, I see one or two have started to put questions in the chat box. Please put your questions there. We'll be coming to Wazi and the questions in a moment. So Nomfundo, quickly, are investors going to invest under this new methodology that's roughly half the price of the previous one? Because we're at a time in South Africa's history where we really need investment in gas infrastructure. Are they going to do it? Yes or no?
I want to say that it is a yes, Dr. Crompton. I still believe that investors will still invest in gas projects in South Africa. Why I say so? Firstly, Professor Firoz mentioned this. I had that point to say that in our methodology, we have considered flexibility. How did we consider that flexibility? It's in two ways. The first one is that, yes, we have come up with this indexation that is based on how the gas prices are determined in other markets. For instance, we included the Henry Hub indexation. We also included the NBP, which is the UK, and then also in Europe. So what we then did, we assigned weights there and did weighted average. So you can achieve a gas price there. And remember, the investors that will come, as you know, are investors that are interested in the in gas to power projects. And you will know very well that, especially in South Africa, you have a situation where electricity has been generated from coal. So coal, as you know, people will say that it is cheaper to generate electricity from coal. Well, there's a lot of arguments there regarding the price of coal as it stands today. However, when you look at the gas price right now, we believe that it is competitive when you compare it with or relative to other markets that we consider to be competitive markets, and is closer to what the regulator is required to do. So that only takes into account, Dr. Crompton, very quickly, the fuel cost. And you will know that when it comes to gas to power projects, the key issue that needs to be looked at when you look at competitiveness is the fuel component of the gas price. Now, when people look at the renewable projects, they will tell you that the cost of renewables is coming down. Now, they will constitute base load. Now, when you then look at how we now say the price of gas needs to be determined, we believe that we are getting closer to that competitive price levels for gas. So the second component, Dr. Crompton, why I say that I still believe that investors will still be interested to invest in South Africa, in gas projects in South Africa, it is because we also provide an alternative method, as we always had it, to the extent that if you were to use this benchmark approach and the outcome of the price that you achieve out of this benchmark approach is not working for you, we then put an alternative, which is the sort of the cost pass-through. And the Constitutional Court, maybe Professor Firoz will come in here, the Constitutional Court also remarked on the alternative method, which is the cost pass-through that we already had before. It said that that cost pass-through is not sufficient. People believed that even the applicant that took us to court, they felt that that was supposed to be the price, and we had a different view. So the Constitutional Court said, no, NERSA, your role is to determine the upper bound, not the lower bound. So that cost pass-through, only what it does is the floor price, is only the bottom price, but you still need to add there so that you arrive at the ceiling. So what I'm saying is that then parties, including those LNG suppliers, if the first method does not work, they will use the second one. In the second one, the onus is on them to convince the regulator in respect of all the costs that they've incurred, and also for us to be able to do our own verification and see whether the price will still be competitive, but also will still be able to enable that investor to achieve what we call in the regulations the reasonable return, and also to take into account the necessary fixed cost associated with the trading of gas. So on that basis, I do believe that investors will still be able to come in and invest. And one must not be confused by the previous price, because the previous price that was existing, it's the price of a monopolist. It is the price from the beginning that was never approved by the regulator as such. It is only a price where the regulator had to only monitor whether that price is determined in accordance with a predetermined formula. It is not the price that was regulated. So it may have put out some signals that were probably unfair signals, if you want, because it was discriminative in nature or discriminatory in nature, and it might have been an artificially high price that could have attracted investment at the expense of consumers. So those will be my views. Thank you.
Thank you for that very full answer. Steve, if we can come to you quickly with a short answer to the question. This legal uncertainty that you referred to, do you think it's going to impact negatively on investor sentiment in the gas industry and other regulated industries?
Well, I will keep this brief. First, starting with the benchmarks. Certainly they represent competitive outcomes in North America and Europe, but to the degree that they may not align to the infrastructure in place and the production costs in Southern Africa, I think there is the potential that there could be a misalignment between that floor price and the costs of developing new fields. But taking Ms. Maseti's points, certainly there is flexibility, as I understand it, built into NERSA's approach that would allow for further cost recovery. There too, though, there are some potential landmines still ahead for investors. When we've seen cost of service type approaches applied to upstream production of natural gas, there's some very tricky questions that have to be addressed, starting with how do you allocate exploration costs across different fields? Can you recover your full exploration costs, or will it be ring-fenced just to an allocation of costs directly attributable to a particular field? If not able to recover full costs, that again would impede investment. There's other issues in using what I'm going to call standard or traditional cost-based methodology, dealing with profits for exhaustible resources. It's well accepted that super profits might be enjoyed due to fantastic production characteristics at a particular field. Those are just considered, economists call it resource rents. It's found in agricultural markets where you might have particularly good agricultural land or a given price, let's say wheat. You don't have a price of wheat for Iowa and for South Africa and for Australia, except for the transport costs. No, you have a global wheat price market. If you have particularly good yields in land, you enjoy the benefits of that, similar to gas production fields. So, and the cost of service approaches that focus on fixed assets and then operational costs aren't terribly well situated to address those issues. We found where it has been used in natural gas, it's been a problem. North America had that type of methodology through the 50s, 60s, and 70s, and it's probably a leading reason for reform of their gas markets, which leads me to a final part of this answer for you. I think it could be time that South Africa reevaluates the costs and benefits of its fundamental legislation, in which where competition is found to be inadequate, the regulator is to approve maximum price. It could be that the benefits of deregulation could possibly outweigh the benefits gained from regulating the sector. I'm not meaning to provide an opinion or an answer to where that balance lies, but I do believe that question has to be addressed now. Thanks
very much, Steve. Firoz, last question for you. This hard look view the Constitutional Court's taken. In other jurisdictions, has that impacted negatively on investment, do you think? I can't hear Firoz.
Sorry, Rob. Forgot about that. I was muted. This is a question that goes to the proper relationship between courts and regulators. And if you like, this on a spectrum, the degree to which courts should defer to judgments made by the regulator on the grounds of economic expertise or because the decisions are complex, or because multiple interests have to be balanced, which would lead to a court to take a more defensive, more cautious approach to its task of exercising review in order to achieve legal accountability, as opposed to this hard look review where the court is basically saying to the regulator, we're going to hold you to a high standard. Now, that's got nothing to do directly anyway with the question that you're seeking to address, which is whether or not the actual decision that it came to, which it could have come to on a less exacting standard than it adopted, I think, to come to the conclusion that a pricing decision which took no account at all of actual costs was not rational. So the conversation is not really about the approach that the Constitutional Court adopted, but more properly, I think, in the domain that perhaps you and Steve are pointing, which is there an underlying, a different debate to be had about our legislative and policy framework for regulating or managing energy policy, and specifically the gas industry. That's a different, a different conversation. I think that you are framing this question as if the problem is with either with the standard of review or the decision that the court made. I think that the court cannot be too strongly criticized for coming to the decision that it did, given the existing legislative framework. So to the different question that you are raising, it seems to me, which is the economic question, it seems to me that you're calling into question both the response in South Africa to over the last 20 years, following other jurisdictions, was to deal with what were previously state monopolies, to allow privatization, and then to try and achieve other objectives through regulation. So it was privatization plus regulation, plus competition policy. Now, I would say that investors are also looking at the rule of law. They're looking at investing in jurisdictions which uphold the rule of law, which have independent courts, in which the rules of the game are certain. And to that extent, I think the Constitutional Court's decision does help, because the court has now said to NERSA, this is a mandatory rule that you have to adopt within a range, which, as far as I'm aware, is fairly consistent with the mainstream policy response in most jurisdictions. So I'm not sure that most jurisdictions have adopted, have deregulated, both privatized and deregulated, which has implications for investors who want to enter the market. I would assume I'm raising these questions perhaps more as questions, because I'm not, I don't have strong views. I don't have the expertise to adopt a fixed position. But I would have thought that we have a dominant player with market power in South Africa. Unless investors are investing in its shares, many of them will be interested in a more competitive market, will want to ensure that if they're investing, that they're not at a disadvantage in a market which is controlled by an incumbent which clearly has market, the ability to control the market and therefore to control pricing of
Thanks
inputs.
very much, Firoz. Much appreciated. So there's been quite a few questions coming in to this interesting discussion. Lwazi, I'm handing over to you now to try and manage the questions. I don't know if we'll have time to get through all of them, but over to you now, Lwazi.
All right, thanks, Rod. Afternoon, everyone.
Afternoon.
Okay, so I'm gonna go through the questions as I see who they directed towards. I think the first question that came through was from Daryl. And I think this is to Nomfundo. And the question was, does the pass-through approach for LNG costs fall away now? And how will the new methodology using the basket of pricing hubs, will it mean in the future that actual LNG acquisition costs will be kept by the methodology plus the shipping cost? I think, yeah, those are the first two questions from Daryl. Nomfundo, would you like to respond to that, or do you want me to add another one?
Let me quickly respond to that. Daryl knows the answers to these questions. We've had a meeting with him, but I would like to. I think he summarized the issues, and I think that question he might have directed it to JP Menkis, Mr. Menkis from Sasol. It was a response to him regarding the basket as he understands it, to confirm that currently we're going to be using the indexation of the three hubs, they had the hubs in the US, and then the TTF as well as the NBP in a basket and put the weighting. So he understands that will be the first option. The second option will be that pass-through, and he indicated that the pass-through will be regulated by a ceiling, and that ceiling will consider the price in the Asian market using the JKM, as well as including the freight costs. So he understands that very well, that the previous cost pass-through approach that we used in the previous methodology, and to the extent that the Constitutional Court criticized it to say that it is not sufficient and it is not achieving what NERSA is required to do. It is the bottom only. So we need to get to the upper bound. So he understands it. And then the only part that he was trying to understand is what will happen with the local projects if the drillers, if you drill gas locally and all of that, how will that work? And I would like to just say that it will be, the pricing will still be based on the two methodologies that we have, because NERSA is the only body currently that is required by law to determine prices of gas. So it will only be those two methodologies currently, but to the extent that things are not working, we will also engage with stakeholders and see whether in the future or in the near future we need to then revise our methodology, review our methodology to the extent that it is not working very well for other circumstances. But as things stand, to summarize, the two methods that we have adopted are the ones that will be applicable. That is the short answer. And then with regards to the question regarding the acquisition cost, we haven't clarified it much in the methodology, but we will issue a what we normally call a question and answer, or frequently asked questions, and then we'll send it to stakeholders and also put it in our website to assist the stakeholders to understand how we determine acquisition cost, and because sometimes they will differ, and other companies take an issue with what we are proposing at the moment, but we are still getting there. So we will issue a frequently asked questions. Those are the two that I've picked up just to assist Lwas.
Thank
Thanks.
you. The other ones, okay, it's more of a comment, I think, from Dion, just talking to the outcome, or what it says the overall test really for the, for the outcome of economic regulation, if it actually mimics an efficient market or not. I think the comment is really just to say that, this is found in most economic textbooks on regulation. Does anybody want to maybe have a comment on that? Firoz?
I read that that statement in the chat group, and it's clear that that's quite an accurate statement, as I understand it, of the case for price regulation, as well as for policies that encourage competition. So nothing to add, really.
Okay, great, thank you. And then there was another question for Nomfundo. I'm not sure if you're going to be able to respond to this, but the question really is, you stated that there's a number of gas suppliers that supported the pricing methodology. And the question is, in the spirit of transparency, can you elaborate on who these are? Or even better, would NERSA be able to share your feedback openly?
I can respond to that question by saying that we held public hearings before we adopted the methodology. So there were a number of stakeholders that presented, including SASOL, and JP is in the chat. I think he also joined the session online. Just to say that he also presented, including the economists that they've appointed, and also various other stakeholders and guest traders also presented, and some of them submitted their comments. I'm not sure at this point whether I should be mentioning their names, but some of them are guest traders that are licensed by NERSA. And following that, we also held workshops again, just to show the results of what we have adopted and what stakeholders were comfortable with. So we can put, I think if it's not there in our website, but the summary of the issues raised by stakeholders, we don't have a problem in putting them in our website and then block out parts that are confidential, and then also the stakeholders that participated in our processes. And we also have our meetings that are open to the public, and also we've shared again after we've adopted the methodology as to who attended those meetings: customers, businesses in the manufacturing sector and all other downstream sectors who attended our workshops, who were pleased with the process that NERSA has embarked on and the outcome of the process. So those are the people, but we can share that information for transparency purposes. But I must also just, the other issue that I needed to clarify is that this maximum price that we are talking about does not include charges for infrastructure. This is what we are talking about is only the fuel cost, just the gas as a molecule, the energy component. So it excludes the transmission cost, liquefaction cost, regasification cost, all the costs related to infrastructure and utilization of infrastructure are outside of this, and distribution pipeline. So it's just the cost of the energy component, just to clarify. So that sometimes when we argue the issue of the fixed cost, as we know that the marginal cost does not take into account the fixed cost, it is not the fixed cost pertaining to infrastructure, but perhaps it could be fixed cost at the production level. So that needs to be understood. And it is not the actual price, it is at the maximum level. Thank you.
Thank you. All right, I think that's for you. Actually, the next question is for you as well, Nomfundo. This is a comment / question from Yusuf, who says, if I understand the pricing policy adopted by NERSA in the past, were you guys just rubber stamping the request of the producers? Notwithstanding that some of them may have been enjoying super profits. And this is without you as NERSA scrutinizing the financials.
Excuse me, as I indicated, I don't know what's happening here. as I indicated earlier, that the price that was charged for the first 10 years since the first gas that was imported from Mozambique to South Africa, for the first 10 years, NERSA did not have powers to regulate or to determine the price at all. All that NERSA was doing was simply to monitor and to check whether the price is determined in accordance with a predetermined pricing framework. And that was the market value pricing. So it simply meant that even if you are two competitors, if initially you were using coal to as a source of energy, and the other one was using LPG. So the one that was using coal, because coal was cheaper, and in terms of that method, one could arrive at a price, say 35 rand per gigajoule. So company A will pay that 35 rands per gigajoule. Then company B, because company B is using LPG, and LPG is regulated by the Department of Energy, and the formula arrives at the price that is higher, it means the one who was using LPG before converting to gas, that one could pay a price of about 250 rands per gigajoule. So you can see that perfect price discrimination there. And we didn't have much to do with it, because the role of NERSA at the time was merely to monitor, not to determine. All that we needed to check is whether it has been done properly. And yes, I wouldn't want to say it's rubber stamping, but the powers were very limited. And it was the regime that was obviously trumping the powers that we have in the Act. So that's what happened. We couldn't determine it.
Okay,
Thank you
for that. There is one question from Kulekani, and I think you've already touched on this. And his question was, does new LNG maximum price for third-party traders include transport costs? And if the pass-through costs are not part of the price, how will these be accounted for by third-party traders?
I've already indicated that it's only the fuel part, the energy component of the cost is the charge in terms of the law, the charge for energy component for the molecule, and then the charge for infrastructure or utilization of network services is called a tariff in terms of the Gas Act. So here we're dealing with price, which is the different thing, which is the charge for energy component. The tariff is something else. It will be the charge for utilization of the infrastructure. So it's excluded. That is the answer.
Thank you for that. And then there is a comment from Thomas who says, there's international majors that looking at developing infrastructure in the country, despite this judgment. His view is that the issue holding back investment from these majors is actually the Ports Act and energy policy uncertainty. Thomas, I wish you would elaborate what you mean by energy policy uncertainty. But in the meantime, I think if anyone else wants to comment on this, Rod, do you have something to say on the Ports Act or the policy uncertainty issue?
So what I want to say about the ports is not so much the Ports Act, but the ports operators. And if I say what I want to say, I'll probably go to jail. So let me try and find another way to say it. But I think the ports in South Africa, the way the ports are run and operated, are a major obstacle to economic development, a major obstacle. We are trying to be an export-focused economy, and our port situation is really not helping that. NERSA has been involved in, for example, licensing some of the LPG import terminals around Saldanha Bay. And if you doubt what I'm saying, go and look at the treatment that those investors have received at the hands of the port authorities and see whether that's the sort of behavior that encourages investment or not? Answer that question for yourself. But yes, I think the ports really are a little bit outside tonight's discussion, but perhaps we should have a separate discussion on that, although maybe on the fringes of energy, but it is a big deal for this economy in my view. Thanks, Lwazi. We must start winding up in about 5 or 6 minutes or so.
Yeah, I don't think there's actually any questions. Yeah, I think we've actually covered all the questions, unless Dion wants to. No. Okay. No, I think we've covered all the questions.
Well, thank you very much, Lwazi, for assisting with handling the questions there. I think if we were in an ordinary auditorium, I would obviously thank the speakers. Thank you, Nomfundo. Thank you, Steve. Thank you, Firoz. It's been a very interesting discussion, and I'm sure that there are those of us amongst us who feel that we've only tasted the hors d'oeuvres. We haven't yet got to the main course. There's so many more questions we would like to explore, but we're coming almost to the end of the time we allocated for this. So thank you very much for your participation. And I'm over email, I'm handing you a token of our appreciation. I hope you can see it, because that's what we normally do. But thank you very much. And thank you for the questions from the participants in this conversation. Really good, insightful, and tough questions. And I think that's what we need to encourage in these kind of forums, that we ask the polite but tough questions, because we really have to make progress. We've got a serious power crisis on our hands as a country. We need more investment in power generation. That means we need investment in gas, which means we need to have a regime which will allow that to happen. My experience is that, for these kind of things, investors will be looking for offtake agreements, 10, 15, 20-year offtake agreements, particularly for an LNG regasification terminal. So I'm not quite sure how that's going to stack up against this methodology that NERSA has now adopted, and whether it will permit those kind of agreements. But certainly their bankers and lenders will want some kind of revenue certainty to make money available to invest in those projects. But I guess that's something we'll have to deal with at another time. Thank you very much, everybody, for participation. And thank the speakers once more. That brings us to the end of this event. And thank you for the people who worked in the background, Jason, Timbeka, and Zindo, and Michelle, and others. Thank you very much for all the work in the background that we didn't see.
Thank you all. Thank you, Dr. Crompton.
Thank you very much.
Thank you.
Bye.
Thank you. Goodbye.